Hello, everybody. We're going to get started. So this is a panel on frontline justice workers, engagement, innovation, research, and evaluation. I am supposed to remind you, speaking of evaluation, that at the end of the session you need to fill out a questionnaire. The panel, in this panel, what we're going to do is talk about some of the various, for lack of a better word, non-lawyer. Okay, closer. We're going to talk about some of the non-lawyer justice worker innovations that are going on that you've probably heard about. This work going on in Alaska with justice workers. There's a new program in Delaware, and there are programs going on in the Bay Area, in Oklahoma, and in South Carolina. I'm going to start by, let me just introduce of us. First of all, we lost Rodrigo Camarena. He was going to come and talk about an app that he built called Reclamo, but he got sick, so he couldn't make it. So it's just going to be the three of us. And the way we're going to organize this is as a conversation. And what we want to do midway through the session is ask you to participate and enlist you to talk to us about sort of justice worker related innovations that you may be considering, your program may be considering, or your state may be considering. So let me do this before I introduce my co-panelists. How many people in this room are involved in conversations around some form of, lack of a better word, non-lawyer justice worker assistance in connection with where you work or your state? Wow, okay, fabulous, fabulous. So then what we're going to do, and how many of you are at, let's call it a iteration thinking stage? Okay, and how many are in an implementation stage? Terrific, terrific. Okay, so what we're going to try to do is talk some about research and evaluation in connection with the programs that Matthew and James are involved in, I'm involved in, and then midway through the session we want to open it up to those of you who are doing work to sort of brainstorm around the questions of research, engagement, and evaluation. So by quick introduction, my far right is Matthew Burnett. He's a senior program officer for the Access of Justice Research Initiative at the American Bar Foundation. He's also a visiting scholar for Justice Futures at Arizona State University. And he also teaches co-teaches a course at Georgetown on access to justice, legal empowerment, and lawyering for social movements. Right next to me is James Teufel, PhD, who's a visiting scholar at Arizona State University's Futures Initiative and an evaluator for Georgetown University's Institute for Technology, Law, and Policy on one of our justice worker initiatives, and has also worked for the there's a lot here. And he also advises, I'm skipping to something, the non-lawyer representation in landlord-tenant cases and consults with the National Center for Medical Legal Partnership. And he's working on an initiative in Delaware. And I'm Tanina Rothstein. I teach at Georgetown Law Center, and I'm involved in various initiatives, three of which I'll mention. One is I launched a Civil Justice Data Commons a few years ago. That's a repository, secure repository for court data. I'm involved in a program on frontline justice, which I'll talk about a little bit more here, and I'm also involved with the Judicial Innovation Fellows Program, and Jason Taché, my co-lead on that, has organized a panel for later this afternoon. So with that, let me start our conversation. Why don't we start a little bit with context? So, James, could you talk a little bit about what kind of justice initiatives you're involved in?
Sure. I'll speak to two of them. So one thing that I've been working on off and on and contributing to for about 8 years is what's now called right to representation in landlord-tenant cases in the state of Delaware, and related to that, qualified tenant advocates. So in a world 7 or 8 years ago, these concepts would not have been acceptable, and certainly would not have been approved by legislators nor the Supreme Court. But where we stand today is in 2022, the Delaware Supreme Court made a rule change. So they made a rule change to something called Supreme Court Rule 57.1. And what that did was it allowed for non-lawyers to essentially represent tenants in landlord-tenant cases. there was a long history in Delaware where non-lawyers were in the magistrate courts, in landlord-tenant courts. Actually, the majority of representation was done by non-lawyers, but it was only for corporations. They had something else called a Form 50 exemption. So if you were a corporation, you could have non-lawyer representation. And if we went back in time 8 years ago, that was totally equitable because there was some belief that a landlord or a tenant could be a corporation, right? And it took 7 or 8 years to come to the conclusion that the corporations are the landlords, not the tenants. And so we got to a point of more equity by that Supreme Court rule change that allows for qualified tenant advocates. Qualified tenant advocates are essentially non-lawyers who work under a supervising organization in the state of Delaware. And in the state of Delaware, there are 3 legal aid organizations. Those are the supervising organizations. They provide the training for the qualified tenant advocates, and they are linked to an attorney as a supervising attorney, although that attorney does not need to be present when they're engaging in services, but they have to be responsive if there is a question that emerges. In addition to the Supreme Court rule change in Delaware, which allowed for qualified tenant advocates, one of my interests is always, those things are great, but how are we going to pay for them? And right now in the United States, there's a right to counsel movement, and we had a heart-to-heart in the state of Delaware, and I said, where will all these lawyers come from if we pass right to counsel? Especially in a state of Delaware that is largely corporate law, and if you're a lawyer and you step into that state and you have student loan debt, the corporations will pay you pretty well to go work for them. And so one of the conclusions we came to is we should push for right to representation, which is the idea that either a lawyer or a non-lawyer could represent you in a landlord-tenant case. And what we did was it took us a few years, but we had, as of 2023, the legislature passed Senate Bill 1 in the 152nd General Assembly, which allows for right to representation and also funds it. So one that's fully scaled in an ongoing legislative budget line, there'll be about $3 million or so a year to support the right to representation concept. The other thing I want to talk about is the Utah Sandbox. Some of you may have heard about the Utah Sandbox in other conversations that have occurred here. I was the founding data director of the Utah Legal Sandbox through the Office of Legal Services Innovation. That was stood up by the Utah Supreme Court Standing Order 15. There were a lot of interesting learnings out of Utah. I'm also still the founding data director of Ontario in Canada's Legal Sandbox. The idea of legal sandboxes is either to allow alternative business structures and or alternative legal providers to have some sort of waiver based on the rules in that jurisdiction to engage in services. And the idea within the sandbox is because you have this waiver, we're going to collect more information on what you're doing so we can better understand what you're doing in the world. So I've been to some other talks. Originally, when this concept rolled out of sandboxes, it was around risk-based regulation, right? Because everybody's afraid of harm. And entities were classified as low risk or medium risk and high risk. We changed that pretty quickly, and in Ontario, we certainly don't talk like that. In Utah, they no longer talk like that. It's more along the lines of low innovation, moderate innovation, and high innovation. The further you get away from the traditional practice, the more innovative you are. And with that as a concept, what we want to do is to collect more information from you so we can learn more about what you're doing, right? Also, if you're an entity in the world and you need to pitch what you're doing in the world, it's really hard to go to a place that would fund you and say, I'm a high-risk entity. I may be in the sandbox that's sort of a pilot. Please give us millions of dollars. We might kind of be around, but we're super high risk. It's also a problem if you're trying to get insurance and these types of things. It's much better to position things which is more real, that these are a continuum of innovation rather than a continuum of risk. If we knew risk already, we wouldn't need sandboxes. Why would we need to do this as a practice? What the sandbox does is it collects more information to better try to identify harms and intervene in those harms if they are emerging, and integrates a different way of looking at the world from a legal perspective. So you're looking at entity regulation, which is a bit different, and you're also regulating legal services, not like the client interactions. So within that, there's a bunch of training, especially to traditional lawyers, about how to report your services, what is a legal service, and so there was a lot of work that needed to be done there. But once we did that, now you're able to regulate legal services and also audit those legal services, which is something I'll talk about more later. But I just wanted to give a brief overview of some of the things I've been recently involved with.
Thank you. Matthew?
Yes. Good morning, everyone. I think it's still morning. So for purposes of this panel, I am the co-principal investigator on a National Science Foundation funded grant called the Civic Innovation Grant. It's a little bit unusual for the National Science Foundation in that, which typically funds sort of basic science, in that it's a competitive process that requires researchers to engage with community actors, organizations, and other partners to propose some kind of intervention. In this case, the track that we received an award for was community services, and then work with researchers to develop an evidence base for how to scale that innovation and think about questions of sustainability and transferability. So it's kind of a two-part process. There was a planning stage that we were awarded that was around $50,000 to help us to do a year's worth of planning, which mostly covered travel. And then we were lucky enough to be selected as one of the final awards for $1 million to scale up the innovation and support both research, but primarily most of that money is going directly to the community. Our partner in all of this is Alaska Legal Services Corporation, and the project is their Community Justice Worker Program. So this is, as you heard this morning from Nicole, a program that trains and mentors community justice workers to provide legal advice and representation. These are culturally responsive, they're embedded members of communities, they're close to the problem, and thus we think close to the solution. And for the purposes of this panel, I guess two things that I wanted to share. One is an innovation around regulation, and that is last year ALSC worked, as Nicole said, on a committee to develop a UPL waiver that allows ALSC to mentor and support non-lawyers who are providing limited legal advice and representation. And then I think a couple of other insights about the program, which are really important for this panel and thinking about research and evidence, are just some of the numbers. So there are over 400 community justice workers that have been trained or are training. So I think for a lot of us who've been working in this community for a long time, that feels like a lot of scale in a relatively short period of time. These folks work across SNAP, they do wills, they do debt-related work, domestic violence, ICWA, and I think really importantly, over 30% of them are Alaska Native or Native American. So if you look at ALSC's staffing diversity, that's around 12%. And so just the ability to engage with communities to bring community members on as partners in providing legal advice and representation leads to diversification of the pool of helpers that are available. And then until really recently, all of those folks have been supported by one staff person, one FTE, Sarah Carver, who's sitting here in the audience. And they have a 100% success rate on all of the applications that they filed. So this aligns with what we know about research on non-lawyer models, but I think it's really impressive and worth lifting up, and certainly worth research attention, which is what we'll be talking about today.
As I said earlier, I'm wearing two hats here. I'm the moderator, but I'm also involved in a justice worker innovation. So a number of you probably have heard of Legal Link in the Bay Area. They, about a dozen years ago, created a legal first aid training for social service providers, nonprofits in the community, and they've been very successful. And we've now replicated their model in South Carolina, in the Tri-County Charleston area, and Oklahoma has also replicated it. And the basic idea is that you develop a training that's specific to the state, and then you reach out to social service organizations, nonprofits, and you have case managers trained in legal first aid so that they can identify for their clients legal problems, serious, serious legal problems before they become even greater crises when they get to courts or lawyers. And James has been doing the outside evaluation for that. So that's a fourth innovation that's on the table. So first question is, I think, research. And so Matthew, I'm going to start with you to talk some more. You mentioned some of the research you did, but I'd like to hear a lot more, or we'd like to hear a lot more about kind of research you did, how you approached research, why it was important.
Great. So I think it makes sense to talk about research in two ways, and also to think about, so evaluation is part of research, but research obviously extends beyond that. One is the research that exists, although is limited, about what we know about roles for non-lawyers in different contexts. So some of that research has happened in the US, and particularly Becky Sandifer and Tom Clark did a great study of port navigators, social workers, and other models in New York State, and found that the most sort of hands-on model with social workers resulted in 0 evictions. So we know from studies like that it doesn't seem like whether or not you're a lawyer or a non-lawyer is having an impact on those kinds of outcomes. We also have research from the UK where Richard Moorhead did a study, and he looked at solicitors and non-solicitors and did an audit of their work product. And it turned out that across the board, everyone is getting it wrong about 20% of the time. But that's consistent among both lawyers and non-lawyers. But what's really interesting about this study, it showed that the percentage of audits that were rated excellent were actually higher among non-lawyers than they were among lawyers. And we think a reason for that is because the folks who are doing this kind of work are doing it routinely. So it's not 1 or 2 cases in the context of a diversified practice. Instead, it's the thing that they're doing day in and day out, and that leads to them to excel in those contexts. Then there's also, so there's other research, some out of Canada and other contexts that show those kinds of impacts. Herbert Kritzker was a now retired professor at Minnesota, did a great study as well. And then the other kind of research I think that informs this is legal needs studies. So these have sort of developed, blossomed over the last 2 decades, and have really shifted the way that we think about developing justice solutions. So rather than looking to formal law, courts and lawyers, to understand what justice needs are, instead these studies ask everyday people how they experience the law and what kinds of legal problems they have, and take a much more people-centered approach. And so from sort of that literature and work that folks are doing around legal consciousness and social legal studies, we know much more about how people encounter the law. One of the things we know, for example, is that the thing that people do most often is nothing. So when they have a legal problem, inaction is the most likely response. We also know that from Rebecca Sandifer's research, most people don't actually understand their problems to be legal problems, to have a legal dimension. And then we know that a very small percentage of problems actually get to formal law, get to courts and lawyers. 15 to 20% is pretty consistent across legal needs studies in different countries. And so that should help us to maybe shift the way that we think about how we provide services and how we think about addressing the justice gap. And from that perspective then leads us to ways in which we would develop service interventions that are actually in people's lives, right? That are close to them in ways that a lawyer at legal aid or a law firm is not. And I think that's really a motivation for thinking about these community justice worker models. Then the second part of the research, I think, is okay, well, if we have these models or are beginning to develop these models and they're emerging in the world, how do we embed research into the DNA of thinking about the ways in which to implement these models, but also how to scale and sustain them? And so a lot of the NSF research that we're focused on is focused on those questions. So effectiveness, scale, sustainability, transferability. These are all things that we just don't get with lawyers, right? Lawyers have increased fourfold over the last 50 years. Access to justice crisis has only gotten worse. And so lawyers are clearly part of the solution, but they're not at the center of the solution. And I think all of the evidence points to that fact.
James, can you talk a little bit about research in connection with either of the two innovations that you mentioned?
Yes, so I'll talk about Utah first and also break out research or this evaluation concept a little bit more, because people tend to, when they step into this research world and they go to too many conferences, just think it's outcomes research alone, right? That's not all the types of research. So for example, in Utah, if you want to develop something new in the world, like a legal sandbox, and you want to regulate legal services, there's research that has to happen, like what is a legal service? What is our coding system? So we had to develop standards for coding, and at first they were kind of bad, because that's how you do it when an innovation shows up in the world and you have to do things while you're creating the system. Over time, we worked with, there's something called SALI LMSS, and we've looked at LSC coding and all these types of things, and we considered, how can we sort of describe what legal services are and what legal matters are a bit better? And we got better at doing that, and that was a really important step. Other formative research or process research that was really important in Utah was around the idea of, at first the sandbox was going to be this pilot for like maybe 2 years, maybe 4 years. And part of the reason you want to have an interdisciplinary team to inform your discussions is, when I walked into this, my immediate response to that is, this is really bad. Right? If you want to raise capital, one thing you know in entrepreneurship or innovation, concept development in and of itself could easily take 2 to 3 years. And if you're only left with 1 to 2 years and you're pitching someone for capital, what the person knows who's going to invest in this is it will be a loss. So we extended the sandbox pilot, right, based on that simple conversation of blending entrepreneurship research in a legal world. And the sandbox got extended to 7 years under that idea. That's going to be the absolute minimum we need to understand what the impact of the sandbox will be. Other important elements of research, because I agree with everything Matthew said, but I don't want to repeat anything he said, so I'll spin off into some of these other worlds, is in a sandbox, and in entrepreneurship and in innovation, to some degree, it will be a numbers game, especially when you don't have formal grant mechanisms or loan mechanisms or incubators. So you're going to have a lot of entities come in, right, to a sandbox. You're going to have 100 entities come in, and when you look at what would be a social impact, you're going to have to be prepared to wait 10 or 15 years, because by the time those entities mature and grow and scale, it will take that much time. And there's probably only going to be about 15% of those entities. So if you have 100 come in, 15 of those that are these big scaled, great entities. I think, there's a couple, I won't name them all because I know some people are here and I don't want to leave an entity out in Utah, but there's been some entities that seemingly will be scaled and sustainable. On top of that, one thing I was really interested in with regard to what is the impact of the Utah sandbox was around the idea of, how much have we gotten out of this for what we've invested into it? And one of the things I was interested in related to that is we're kind of creating a soft incubator when we create a sandbox, right? You're saying you're allowed to do this, but go get the money. And one of my interests was, how much money are entities investing in this, right? Because if you ask any public entity right now in the country, does this cost too much? It doesn't matter if it's $10 or $10 million, it's always going to cost too much. So what we looked at was not only how much the state was investing in the sandbox, which was relatively minimal, but how much entities were investing. Entities have invested millions of dollars of developing these legal services into the world. And when we look at what they've done and what is the potential benefit or harm of that, a lot of the Utah Sandbox as a risk-based framework looks at the risk, right? And the harms arguably are less than what you would see in traditional legal practice. If we look at the ratio of services to harms, that also makes sense. Another place I work is Ontario. When you compare non-lawyer paralegal service complaints there to lawyers, the ratio of sort of services to complaints is lower for those paralegals than lawyers. So that's some of what we found or have thought of or considered. In Utah, there's a lot more. I'd be happy to talk about it.
I want to stay on research a little bit longer and ask you, Matthew. So we heard from both of you about research that shows that the sky does not fall down when you have someone who's not a lawyer providing a service, and in fact, in many situations, they do as well, if not better than lawyers. But I was wondering, in the context of Alaska and community justice workers, what kind of research did you do in the community around developing the program, the intervention, the trainings, how you prioritize certain areas versus others, and how did you get community engagement in the project?
Yeah. I mean, so one clarification is just the program already existed for several years. And this research was really focused on how to scale it up and learn from evidence and research that we were doing to make it more effective and impactful. So the fact is, Gillian Hatfield says the world is law thick. That's true of justice workers too. There are actually all kinds of justice workers already operating in the US. These are tribal lay advocates, these are accredited representatives in the immigration context, all kinds of people who are doing or providing supports in federal administrative proceedings. There are jailhouse lawyers who are authorized constitutionally to be able to provide legal services in institutions. And so I think one part of that is recognizing that, but then also recognizing where there are limitations. And a lot of those limitations fall under restrictions on UPL, which most states actually criminalize in the US. So as we were thinking about this, we were kind of thinking through a couple of different strategies. One is that the Civic Innovation Grant is focused on innovation. It's focused on scale and sustainability and transferability. And so what are characteristics of the programs that lead to those things? And what we know is, in addition to the fact that, we can't scale lawyers, the more constraints that we put on programs, both in terms of credentialing, but also in terms of licensure, the less likely they are to be able to scale. And we saw this with the Washington LLT program, which ultimately was sunsetted because it didn't really get sufficient adoption or resources. We're seeing it with a lot of the licensed paraprofessional programs, at least now. The uptake of those programs is pretty limited. But then I think we also see it as we think about the ways in which we've tried to design programs in the past, so things like limited scope representation or other kinds of innovations where we build so much complexity into the model that it actually becomes more difficult to be able to scale up and replicate that model. So that's one thing that we're really interested in. And the insight in Alaska, which I find really encouraging, is that there's very low barriers to entry. So we're not replicating all of the things that we've put in place for the legal profession, like character and fitness, which of course were a lot of communities that we're supporting, is a problem because they're over-enforced, they're over-policed, and there's all kinds of ways in which people find themselves bound up with the criminal justice system. Training, amount of training, testing, credentialing. In Alaska, there are asynchronous online training modules. They're about 8 hours. They are self-paced, so people can do them as part of their jobs or as part of time that they have available that's not requiring them to take a bunch of classes or do a bunch of testing. And then they do the important thing, which is they're mentored by an ALSC attorney to take a case and do a case, right? And we know that that kind of hands-on practical training and experience is really what's critical. The other insight, I think, is that they're not trained to be generalists, and this is really critical. So we're not training lawyers, right? We're not training folks to be able to do everything. They're trained to do a very specific kind of intervention that's relevant to their circumstances and where they sit in communities. So a great example is the tribal land workers are trained on wills to prevent fractionalization of land in Alaska. That's what they're trained on. That's, I think, about all they do, at least the tribal land workers, right? And it's a really critical intervention that is having significant impacts in communities to prevent fractionalization, but they're not trained on 15 things. They're trained on the thing that's relevant to their work and that's relevant to the ways in which they're embedded in communities. And so I think thinking about ways in which we can simplify programs, not erect barriers, all of the research suggests that this is the way in which you scale these things. The second piece, which you asked about, Tanina, was the kinds of research that we did early on. And we're really fortunate to work with an incredible anthropologist of law, Michelle Statz, who's the PI on the NSF grant, who did a bunch of essentially ethnography with communities. And so she did interviews of 18, I think, individuals and focus groups. We met with over 20 different partners in Alaska and really sought to understand both what the needs were, how existing interventions, the Community Justice Worker Program, was having impact, and concerns that they had about the kinds of things that we wanted to understand, like could these things scale, or how would we sustain them over time? And so we got some really important insights. Like, for one thing, and we all know this as people who've practiced in legal aid and other public interest contexts, burnout is real, right? These folks, and particularly in the community health aid context, are having to deal with some really serious community issues, including, poor health, including domestic violence, all kinds of things that make it really hard to be the center of help within particularly small rural communities. And so part of the development of the Community Justice Worker Resource Center, which is kind of the core, the hub of what the project was trying to develop or has developed, is ensuring that that kind of well-being and care for community justice workers was centered alongside the legal training and support. And so we knew that that was going to be critical, not just to financial sustainability over time, but to individual well-being and sustainability within communities. And then the other thing on the sustainability piece that I'll just mention quickly and then wrap up is that one of the real innovations of the Alaska Community Justice Worker, and this comes through in the research, is that the program is cross-subsidized. So many, not all, but many of the community justice workers are paid by the organizations in which they're embedded in. So until very recently, ALSC didn't pay for any community justice worker, right? They weren't on staff at ALSC. And that creates all kinds of opportunities for cultural competency, for language competency, for just understanding of a community. But it also means that the sustainability of the program doesn't require hiring full-time staff to be able to scale up these programs. And so these folks are volunteers, or they're already embedded at organizations. Those organizations are paying their wages, and this is just part of the work that they do in communities. And I think the more that we can leverage that kind of cross-subsidization, community partnerships, as a longer-term sustainability model, the more likely it is that these programs will be sustainable over time.
Great, thank you. So I want to pull out some threads from what we've heard so far and focus on evaluation and think about sort of buckets of evaluation. So when I think about the traditional evaluation of lawyers, there's a fundamental do no harm principle that tends to be enforced after the fact, right? A lawyer malpractices and then gets sued or is brought before a disciplinary committee. And then there's the idea of fidelity or consistency, training somebody and making sure they know how the process works, how the law works. But I think what I heard between you is an idea of effectiveness, social impact, sustainability, scalability. So I think it'd be worth spending some time talking about those categories and how you might think about what they mean and how you might go about evaluating them. So,
great. Thank you,
away,
Tanina.
James.
So just as one quick point before that, I'll just reiterate what Matthew said about training. So with the Delaware Qualified Tenant Advocates, one of the things we intentionally did was when the Supreme Court was writing the rule to just say, we're going to train around like 3 or 4 very general things that would be applicable, right? Like, how do you act professionally in a courtroom, right? What is landlord-tenant law in general, right? These basic things that people would need to know. What we avoided at all costs was hours of training requirements. So because they're arbitrary, meaningless, and just thrown up, or they're attached to an anchor of like, this is how much a credit would be in college, and this is how many hours. So the focus, if you are going to push for this work and how things work in the real world in organizations, is the focus should be on the type and quality of training, not the random quantity of training requirement. Okay, I'll get off that. But related to the quality of things, I'll speak about this briefly and then get into some other things. One of the things that did happen in Utah was for some of these higher innovation entities, we wanted to understand the quality of the services that they provide in the world, because sometimes the quality of the service and the outcome could be disconnected, right? You could provide a really quality service, but if you get a judge, as an example, that just doesn't care, you won't have a good outcome, right? So in Utah, what we did to try to better understand the quality of the higher innovation entities was to develop a legal service audit. And I thought this would be easy. This would be done everywhere, right? And as I learned in law, like there are audits of like trust accounts, but not law audits of the actual legal services themselves that are formalized. So what we just did was we developed a fairly cheap and easy method to do something like a peer review medical chart in medicine. So it's like a peer review legal service chart review. And so entities are asked to send along data on what were the consumer's wishes, what did they want. And then the next bucket of things we asked them to provide documentation on is what actions did you take? So it's a wishes and actions checklist of information. And we send that off to 2 auditors, panelists, and then they rate the services from very poor to excellent. And then if it's poor or very poor, we ask them to explain, and we look at how that links to rights results or payment issues and follow up and try to understand better. So that quality thing is very important. One thing that I have found is some of the what I'll call social impact research that's been done in Delaware and other places is really important. So I had 3 years of court docket data from the state of Delaware, and I worked with a colleague who's a computer science expert, and then he helped to transform that docket stuff into something I could analyze. That docket data, I then teamed up with Neil Steinkamp of Stout, if you've heard of the Stout reports, and we partnered to develop a social impact assessment. Like if we did this right to representation thing in Delaware, what would be the cost-benefit analysis? And so what Neil concluded from this partnership of data things was if you invest $1, we're going to save 3, right, type of concept. And that was part of the formative work here, right? So one thing these social return on investment reports can do is potentially estimate the value of your work before you do it, right? Something like a randomized clinical trial or controlled trial, you have to kind of do the work and see what happens. There are ways relatively cost efficient that you can estimate the value of your work. And I've seen a lot of impact, not only in Delaware, it was qualified tenant advocates, but in medical legal partnerships. I was involved in doing financial return on investment, social return on investment work for MLPs over the last 20 years. And that seems to move the needle more than some other things in the world. So I'd highly encourage considering social return on investment types of analyses. Some other things that Matthew has already spoken to, right, is you want to understand if consumers like what this thing is, but something also that's very important is does the provider like that? And so we've looked at those types of things as well, not only the consumer experience, but what's the provider experience. And then there's a great battle between 2 other things in the world, something called efficacy and something called effectiveness, right? So efficacy is the idea, if you've heard of RCTs or randomized controlled trials, right? It's to make things really pure and to find what that purest result is of what's the impact of your program. Oftentimes that may raise ethical concerns or logistical concerns for entities in the world. So I wouldn't say if you can't do a randomized design, that's fine, right? But still try to consider an idea of effectiveness where you may be trading off accuracy, perfect accuracy, for something like feasibility or utility, right? So in evaluation work, one thing to always consider is you'll always be making trade-offs amongst accuracy, feasibility, utility, and ethics, and to not just hyperfixate on one of those things, because it probably won't move what you want forward, but to try to think about what's the best balance of those things.
Great, thank you. So Matthew, you used the word effectiveness too, I think, so I'd like to hear your thoughts about that. But I'd also like you to speak to the issue of a larger sense of social impact or community empowerment.
Yeah, so for the NSF work, the evaluation framework includes legal empowerment as part of a measure of effectiveness. So part of the goal of that program is to empower individuals and communities to learn about the law and use the law. I think the way to measure that is still nascent. There's some great work that's happening right now in Australia. Nigel Palmer, who is the research director at Victoria Law Foundation, has developed a new pulse survey that's looking at legal capability and other ways of measuring how people engage with the law and ways in which that builds capability or doesn't build capability. I think that the challenge sometimes is that all the systems that are in place are not necessarily working towards that same goal. So when we think about what legal services are or the role of courts and lawyers, oftentimes the idea that we're empowering communities to be more engaged with the law and use the law is not part of the ways in which those systems are designed, right? Justice is done to them. It's not something that they actually have agency in. And so I think shifting the evaluation framework without thinking about the ways in which the kind of institutions and our justice lives are designed is a challenge. I do think that there are ways in which the justice worker model, because it's actually empowering individuals in communities to provide services and support, lends itself towards this kind of evaluation, a more sort of people-centered approach to evaluation. And so I'm encouraged by the idea that the model itself will be able to help us to better understand how to study and how to understand legal empowerment in communities. But I think it's still nascent, and it's nascent here, but it's also nascent globally. There just aren't a lot of studies or research that's happening around legal empowerment using empirical methods.
And what about community empowerment, if you have thoughts about that? Because I tend to think of legal empowerment as in somewhat, legal capacity is more individual, and so.
Yeah, I think about them as being one and the same, but a really good example of this in Alaska, and there's an almost exactly parallel example from South Africa when I was working there, is that one of the things that happened during the pandemic is the state wasn't effectively processing SNAP benefits, right? And so it was through this work of community justice workers that ALAC was able to intervene at the community level, but then that also raised the consciousness of individuals and communities in the systemic problem that was happening at the state, which then supported litigation and advocacy and other work. And so I think it's not just a question of sort of empowering individuals to better understand the law and to use the law, but in the legal empowerment model, a third part of that cycle that we talk about is shaped law, right? So the more empowered individuals are, the more likely it is that they're going to be familiar with the systems that are at play in their lives and the ways in which they might be unequal or insufficient in addressing whatever their legal needs are. And I think that the Alaska example, there's also, as I said, in South Africa, a group called Black Sash was doing work around of public benefits there, and it's community paralegals were the ones that recognized that there was a problem, and that led to systemic litigation at the national level. That kind of thing is really exciting, I think, really encouraging, because it's not just about addressing an individual legal need, but it's actually building legal consciousness and awareness in communities, so they're more likely to take action in the ways in which the law is impacting their lives.
Great, thank you. So a number of you raised your hands when I asked earlier whether you were contemplating or implementing justice worker type innovation. So what I want to do is welcome anyone who's sort of in the beginning or the middle or the implementation stage of a project to describe what you're doing, and if you have questions or want to brainstorm about something that's come up or issues that you foresee coming up, be happy to do that. Sure.
Matthew, in terms of sustainability, are you measuring the ongoing support after training that the legal services program in Alaska has to give to keep the enthusiasm, the sense of agency of these local workers?
Yeah, and it's one of the things that's a great question. So the first thing I'd say is there's different types of support, I think, that are required for programs to be sustainable. So there's that, the support that ALSC, the organization, is providing on an ongoing basis, and that goes both to the training and the credentialing and mentoring, but also to well-being, as we suggested earlier. So part of the staffing model for the Community Justice Worker Resource Center actually embeds that kind of well-being support. But there's also community support, right? And that's a really important question. Do communities actually embrace this as a model? And how do we know what the long-term impacts are at the community level? And then there's political support. So, for example, if community justice workers are out there being really effective at getting things done in the world, is there going to be backlash or other kinds of pressures on community justice workers or the program because of the kinds of impacts they're having? And then, just sort of general financial support. So, or is there a way, and I spoke about the kind of cross-subsidization model, borrowing staff, FTEs from other organizations. But I think on an ongoing basis, these kinds of return on investment analysis, like really understanding what the impact is for communities and cost savings for things like, yes, less utilization of emergency services or other kinds of, policing or community infrastructure, and is that a cost saving such that you would invest that money instead into these kinds of programs? So I think there's a lot of research that needs to happen around sustainability, and a big part of it, as you suggest, is around just the culture of support, which goes well beyond just training someone to write a will, right? It's an ongoing relationship. And I don't have, one interesting thing will be, and I don't think that it's still early, what is the level of attrition? How many people take one case versus 15 cases or whatever the case may be? I think it's early days to kind of understand that. But obviously there's going to be a cost benefit to training individuals and expending the same amount of time essentially on a person that's taking one case versus 15 cases. And so we haven't really yet been able to do that analysis of what is the resource requirements for training and support versus the actual productivity of any one individual. The other thing that I should mention is the scope of the program. There, I think Sarah shared with me just recently that the community justice workers are working in 42 different communities throughout Alaska. I mean, even if it's one or two cases, the idea that those cases can actually even be supported in a very rural village or part of Alaska, I think is really encouraging. So just the sort of geographic impact and scale is also, I think, really impressive.
Okay, someone from the back? Well, you're far enough back. Go ahead.
Line up, or
Well, I think I'm going to take this question just because I think my program is the one program that's actually working within UPL restrictions. So I didn't talk much about it, but Legal First Aid, which is first developed by Legal Link and now, as I said, piloted and replicated in South Carolina, Oklahoma, works within the current UPL environment. And the idea is that you can train case managers to identify legal problems, to help their clients find resources, find legal information, and send them to lawyers as appropriate. And we developed a really robust lawyer network where the lawyers, we had the best first calls, et cetera, and that we did that all within the current UPL environment. And the idea is that you can start by doing that, and and Legal Link. So we don't train in Legal First Aid. We don't train our social service providers on every single question. We prioritize Charleston, South Carolina, so we prioritized housing. We also do benefits, and we do some stuff on family law. So there are 4 or 5 big topics that are prioritized, and it's all within the current UPL regulatory system of South Carolina, and that's the same in Oklahoma, and that's the same in California, where it's been very difficult, as some of you might know, to get a regulatory reform. But it really fills a hole in the ecosystem because it gets to people when they're coming to their case manager, the nonprofit organizations who see their clients on a regular basis and who can now are in a much better position to help them identify the legal problems and send them for help.
And I'll follow up on that. So I've been involved in sort of both of those spaces. So operationally, you would want to keep those things distinct. But strategically, you want to reconnect them when reasonable and appropriate, right? So in part because the people involved in, within UPL versus changing rules will be different. The speed of them will be very different. Your aims will be very different. And if you combine those 2 worlds, it will be an inefficiency for you that I would recommend you not go forward to. But you can do what you want. But I do think that thinking about some of these things that are in that grayer area in the UPL world, helping to inform that regulatory reform discussion will be important.
And I think just add that, so one of the challenges about regulatory reform is everything's been lumped together, which I think is actually a disservice to the ways in which these models are appropriate and can move forward now. And so regulatory reform is often a conversation around ABS, alternative business structures, and non-attorney ownership, sandboxes, licensed paraprofessional program. Those are all pretty high bar sort of conversations or I guess strategies. Whereas in Alaska, when we were having these conversations, what we said is it's really this committee. You should definitely consider all of these things, but the thing you should do now is community justice workers. It's available to you. It can happen now. It doesn't have to be connected to any of these other debates. It can be a collaborative partnership with legal aid and other community-based partners, with the courts, with the state bar. In Alaska, the UPL waiver provision was approved unanimously by the state bar, almost unanimously by the Supreme Court. There was one judge who thought it shouldn't only be restricted to ALSC, and I think ALSC agrees, but that was a political compromise. And so I think that that's really the position that I would take, is it's great for the state bar and for lawyers to be discussing all of these different potential pathways to regulatory reform, but the one that can and should happen now is community justice workers.
And just to add one thing, in South Carolina was sued because of its unauthorized practice of law provisions by the South Carolina and the NAACP in South Carolina, and because they have a housing navigators program that started within the UPL space, but then wanted to give advice about evictions. And the federal court ended up bumping it over to the South Carolina Supreme Court, that's now considering an exception to their UPL specifically for housing navigators giving advice about evictions. So that seems to be consistent with the approach that Matthew just talked about, which is thinking hard about what area the intervention is important in, and then building out in that area and then focusing on an intervention that's related to that area, as opposed to putting every single big issue on the table in reg reform. Nicole, you were going to.
Well, I was just going to point out too that in Alaska we started building the program before the waiver existed, right? So there are areas that we could identify that exist in every state in the union that you have a right to under the U.S. Constitution for a representative of your choosing in public benefits cases. So again, we started building out things that you didn't necessarily need a waiver for, and then that allowed for proof of concept when we went to with the help of Matthew and others to get the waivers. So don't wait. I would say nobody in this room should be waiting for anything. The time is now.
And the
Says
other,
Nicole, the
the
time
other
is now.
caution is don't build barriers now, right? I think all of those concessions that you'll want to be making to appease different interests, it's worth just making the case that the simple, straightforward program that requires, training that's reasonable and mentoring and support. In Texas, this conversation is happening well. Recommendations were just made to the Supreme Court for a community justice worker program. Those programs will be restricted to justice courts, which is great. That's a big area of need. But it's already a restriction, right? So there's other areas that, at least in the first instance, it's unlikely that individuals will be able to help. In Texas, it's open to legal aid and other nonprofits. In Alaska, it's restricted to just ALSC. That's another constraint in Alaska. So I think trying to prevent these kind of constraints on innovation and scale from the beginning, and having your court and bar and other leadership trust nonprofits, legal aid, and other community-based organizations to do the right thing is really critical from the start.
Yes, go ahead.
My name is Deborah Espinosa. I'm Executive Director for Living with Conviction. We're a statewide nonprofit organization in Washington State. And we have a legal empowerment program that is technology-based with our legal empowerment navigators, helping their peers process or prepare and process motions related to post-conviction relief. That post-conviction relief is to a great extent within the civil legal aid realm. So we have a lot of civil
so it's 12:15, so some of you may want to go, and some of you may want to stay. Happy to take more questions, continue the conversation.
Yeah, so we're going to host a conference at University of Arizona, or Arizona State University in Tempe at the end of this month, or at the end of February. And that will be focused on justice workers. And you wanted me to mention the research conference. So the day before EJC, we're also hosting a research conference. But the Future of Justice Work conference is going to have frontline justice workers on a bunch of different spaces: immigration, youth justice workers, disaster, housing, all running the gamut of different kinds of justice workers. And if you want information about that, see me and I'll send you information on the website. Thank you.